But you do have all three, like proof that all three signed though in city.
Yeah. No, I don't.
Okay.
I don't have it because I didn't get the video of it. But I do have the website versions for all three. But all three did agree. I just don't have the video of it. Oh, yeah.
Okay.
All
Okay.
right. All right. So if we
Oh wait,
can,
I'm the
we're about to
plaintiff.
start. Let's JB, you and Dad can talk about that after this part is done. I know that's something. What is TikTok doing? Jesus. What's up, guys? Welcome in. Welcome in. As y'all can hear, our theme music is going. Take your seats. Please pay attention. What's up, Passe? What's up, Maddie Boo? If y'all could please share the links out. We're getting started.
Is Landon required to join a stage when
Yes.
Judge Stack is up? Okay.
Yeah.
Good evening, everyone. Good evening.
Am I being heard? My
How
bad.
is, yes. So we are about to get started. For those of you that are joining us in VC and in City, welcome. About to get started in a second here. I just wanted to make sure that, can everybody hear me okay?
Yes.
Yes, ma'am.
Excellent. All right, so a few housekeeping issues or notices rather. Sometimes my headset acts funny.
Are you on
Um,
shout? We can't hear you on the back.
okay, let me see if I can. Does anybody know what to flex to increase the volume
The
or to
speaker
turn the
button.
microphones
F11
on?
muscle.
Thank you. Oh shit. I pressed it and everything on my screen disappeared. Can you hear me in the back now? Can y'all hear me?
I can.
Yes, I can hear.
We can't. Yeah, I can't hear
In
you.
the city, if you cannot hear me right now, just move up,
We gotta turn her up. I can hear her right now.
move closer, or sit in. So you're saying you can't hear me in the front row?
No, we can't hear you.
Okay, so it might not be that F11.
They gonna have to add a mic for y'all.
Yeah, that you normally it comes with.
Yeah, because this room kind of big.
Yeah.
You might have to whip that white chair out and sit off the podium.
No, we tried it
Um.
yesterday. If you put it on shout, we'll be able to hear you.
Yeah, I'm just trying to figure out how to put it on
If that
shout.
didn't work, you can press the key next to the number one.
It's probably your
Testing,
F11 muscle.
testing.
It'll.
She said the F11 didn't work.
Testing. Can you hear me in the back? No. It looks like my mic
I
is all the
can't
way up,
hear her,
but
but I am also watching from the digital courtroom as well. So
yeah. So if we can do that until I can figure out those key binds. I don't want to hold up the proceedings right now. Okay, let me see something here.
I'll
Did
just stay.
everybody have the opportunity to read the memos I issued out today in regards to the rules of engagement for tonight's evidentiary hearing?
Yes, Your Honor.
Why do I hear an echo?
no,
Because I have my snap glasses on.
All right, I got you. I'm just gonna turn everybody down in the hell is going on? That's what it was. Okay. Alrighty then. How's everybody doing this evening? I hope everybody's having a wonderful, wonderful Friday.
Yeah.
All right. So my name is Chief Justice, and I will be presiding over this moot court, second part of the moot court evidentiary hearing covering the case of Bands versus Island PD. All participants, all of you are hereby advised that tonight's moot court session shall proceed as an evidentiary hearing only. The purpose of the proceeding is to review proposed evidence and to determine what, if any, items will be admitted for consideration in trial part 2. Trial part 2 meaning that's the actual trial. Okay, so this is not the trial on the merits, and no party should treat it as such. So to ensure efficiency, order, and proper courtroom decorum, the following rules shall govern this proceeding. So I'm going to go over them one more time with everyone so we understand. So for the prosecution, for the plaintiff and the defense, if you guys could please approach the bench. Not the floor. Where y'all guys go? Okay. Get you guys on camera here. Landon, if you could turn and face, or stand next to JB and face so that we could see you. Sorry, I'm looking through a lens.
Do you
Yeah.
not see me? Like, okay.
No, you're out of the camera. Can you come and stand on the other side of JB on the defense side? You're on the.
Okay, I'm sorry. What?
I just need you to
All right,
stand
I'm
on.
sorry. What, Cameron? Was I
Right.
not right here?
No, you were not, and your back was turned, so we couldn't see you. So just FYI, beyond me watching this, there is an entire audience of people watching these proceedings as well that are a part of this. So they need to be able to see you. So that's why I've asked you to turn around so that they can see you on the camera. Is that okay?
Okay.
All right, great. So each side shall present the title of the evidence it seeks to admit and provide a brief explanation in 30 seconds or less as to why that item is relevant to the case presently before the court. What that means is, just like we did before, each side will get their turn. When it is your turn, you're to give the name or the title of the evidence that you're about to present. Give me a 30-second synopsis of what it is. And then if there's any objection, the other side will say, I object. If you do object, you have to object on a legal basis. And then you get 30 seconds to state that legal basis. After I've heard both sides, I'll determine whether it is admitted or not, and then we move on to the next piece. Agreed?
Yes, Your Honor. Agreed.
Your Honor, so we had to talk like fast, like within like 30 seconds. Like we can't like.
Understood, Your Honor.
Okay, she knows your part, but I'm saying that we only have 30 seconds to speak about whatever. So
In an IRL court of law, it's even less time. But yes, I'm allowing 30 seconds because that's really all you need to do to state the title and subject of the evidence that you're asking for the court to admit. This is not the trial, so you don't need to sit and explain in detail everything. 30 seconds is sufficient enough for me to decide if it's admissible or not.
Okay.
Objection and no objection. Do remember that if you are objecting, you need to object on a legal ground. If you don't use the proper terminology, I will dismiss it. Okay? So make sure you got that
All right.
together. My rulings on evidence and anything else is final. There's no arguing. There's no back and forth. I will not have it. I will hold y'all in contempt. Okay, do we all understand the rules of engagement for this evening?
Understood.
Landon, I didn't hear your verbal confirmation.
Did you not hear me
I
not
just
say
said,
yes?
no, I did not hear your verbal confirmation, which is why I asked for it again.
Okay, I say yes.
Okay, perfect. All right, let's get started. You guys may take your respective sides and we can get started. All right, so just a second here. So before we get, we're going to begin with attendance, so the record is clear as to who is present. After the attendance is taken, I'll provide a brief summary of the proceedings and the posture of the case so that everyone is operating from the same understanding. So, Diamond, are you here with me? Are you on stage? If not, can someone let her up? Or am I the only person that can let her up? I need to go check. Diamond, Diamond, where are you? Okay, I think we got Diamond. Diamond, can you take attendance and make sure that everyone is here as they said they would be, so that we can make sure that we have the official attendance record from the court?
Yes, ma'am.
All right. Once
I
you finish
believe
with,
we have everyone in attendance.
excellent.
Mm-hmm.
Okay. All right. So, all right, moving on. Okay. So, as Chief Justice, my role tonight is limited to reviewing the proposed evidence and determining what will be permitted for the next phase of this exercise. So, right now, I'm talking directly to all the students. I may ask questions of either side for clarification. Now, those questions are intended to test legal reasoning and to help sharpen advocacy, which is the point of a moot court. At the conclusion of this, I'm going to set a date for trial part 2, which is the actual case, right? And that's when both sides will come with their witnesses and their evidence, and they will lay out a story for the jury to determine who should win the case. It's structured after an IRL justice structure with allowances for RP and the fun of RP, right? So certain things may happen here that may not happen in real life simply because we are in a roly-poly situation, if that makes sense. A dream world, you know what I'm saying? So
That's the pasta.
the process, thank you. The process will be as close to IRL as possible, or the dream world as possible. The dream world is possible, but it will also allow for roly-poly. All right. The goal is not, I expect everyone participating to remain professional, composed, and respectful of the process. This is a learning environment. The goal is not drama. The goal is growth. The goal is discipline and a stronger legal practice. All right. Students, those of you that are in the courtroom, just throw your hands up in the air, wave like you just don't care if you hear me. For those in the Discord, okay, I see the hands. For those in the Discord, just throw an emote up in the air if you hear me on those points. Yeah, for those in the emails, just throw a something up to show that you heard. Okay. All right. I'm just going to gather my notes very quickly. Just give me a second. Instead of having a summary done again, I did write out a brief overview of the case. I'm just trying to pull it so that we could begin. All right, here we go. The court wants to remind everyone that this is a civil lawsuit brought by Chase Bands against the Island Love Police Department. The plaintiff alleges that officers used improper force, transported him in the trunk of a patrol vehicle, failed to provide medical care, interfered with his civil rights, and caused emotional distress. The defendant is expected to respond to these claims and challenge both the facts and the legal basis for relief. So what we're doing here in court is we're focusing on the main legal questions raised by this filing. Hopefully all of you had a chance to review the filing. Now the filing is what we care about, the charges that are in there. And that includes whether the plaintiff has shown, and this is important, has the plaintiff shown negligence and personal injury by the police, whether the alleged conduct amounts to battery or excessive force, whether there was a failure to provide necessary medical care, whether civil rights were violated, and whether the facts support a claim for emotional distress. Those are the only things the court is concerned about. Everything else is moot. No pun intended. So when you're looking at a brief, you want to make sure that you break down what they are claiming, what they are seeking restitution for, so that your case is succinct. All right, everybody holler if you hear me, wave your hands in the air like you just don't care, or throw me some love in the ease. All right, good. With that being said, I'm going to ask each side to present their evidence.
Oh goodness, I'm having issues. I'm sorry.
I'm going to ask each side to present their evidence, starting with the plaintiff. Please list, do not go into detail, list the evidence that's already been approved for trial, and then go into any additional evidence that you are presenting to the court this evening.
Okay, Your Honor, just give me a moment to check out the case filing. And then we're also going over approved evidence, like from what I submitted like a day or two ago.
Yes, but you're just going to list it, like each evidence, like evidence part 1 or part 2. I'm also going to show the court the evidence file or the thread that we already have. You don't need to re-explain everything. Okay.
And then the new evidence is just going to come in like part 2 or whatever.
Correct. So you're just going to tell us the title of the evidence that's already been submitted, and then you're going to say, here's the evidence that we are submitting for today, and that's the one you get 30 seconds for. Okay? You get 30 seconds for each one. Hold on, it's not your turn, it's the plaintiff first. In these cases, plaintiffs always goes first because they're the one that's bringing the claim. So it's on JB to present her list of evidence that was approved from yesterday, and then 30 seconds on each new drop of evidence. Let's see if we can do this before 10 minutes. Very quickly. Let's try to get this done in 10 minutes. I think we can.
Of course. So, Your Honor, I will be presenting snap glass camera footage from Chase Bands himself of his initial arrest, where he was stuffed in the trunk like luggage, as well as his following interaction in the police precinct cells, where he was repeatedly uncuffed and cuffed, and his requests for food and medical aid were ignored, and his property was misplaced.
Just give me the title of the evidence. That's all I need.
The next piece of evidence will be screenshots from Birdie where the undercover officer made contact with my client. The next piece of evidence is a list of the property that the PD irresponsibly lost. And nextly is the list of witnesses I will be calling for this case. The last item should have been included with everything else. This is just a image of when my client reached out to the hospital. Of course, I understand that, well, I'm not going to get into that. But the next piece of evidence I will be showing, which I'm waiting to upload to the net, is snap glass camera footage of, or excuse me, Meta Ray-Ban footage of my client finally getting his injuries addressed at the hospital, his MRI, and I'm currently waiting for the documentation of that visit.
Okay. And these are all of your, this is all the evidence that you want presented for trial, correct?
Yes, Your Honor. Any
And these were
moment
the
now,
ones, these were the ones that were already approved. Is there any new evidence to be presented today?
Yes, Your Honor. His medical visit, the Ray-Ban footage of his medical visit.
Okay. Is there any objection from the defense to the Ray-Ban footage of the medical visit?
No, Your Honor.
No objection. Okay, noted. All right, so that piece of evidence will be admitted. Make sure it's uploaded for trial. All right. Do you rest as far as your evidence is concerned? Is that everything?
The only thing that may be new is the document of said recorded visit.
Okay, so and the defense said there's no objection to that, so let's move on. All right, you're done. You may take your seat. District Attorney Landon, DA Landon, if you can let us know your list of evidence.
Yes, Your Honor. My first piece of evidence are Birdie posts from Mr. Chase Vance of him posting basically drug trafficking and also his illegal weapon business.
Objection, alleged miscategorization.
Overruled.
Your Honor,
He's just listing what his evidence are. Let's not bang on bacon. We're trying to get this done. Continue.
I also do have a video of myself going into the prison doing the same motion as Mr. Benz. And in that video, I am perfectly fine to run around like he was.
Okay, what's the next one? Remember, don't languish. Just listing. We're just listing it.
Also do have this is coming from a motion that I filed to dismiss this case. I believe that we went over that before. That was put into evidence just for the motion. Do I have to go through that?
No, that's thrown out. That's not admissible.
Okay. Okay. Also, do you have a video of Mr. Chase Benz evading confinement as he tries to configure his GPS over to Legion Garage after the police had told him to go back to the prison? I do have video evidence of him doing that, evading arrest.
Yes, that is approved for the court. Just make sure it's in your evidence threads.
Yes, Your Honor. I also do have a message from the overseer of EMS.
Oh Lord, I hate
Katie.
that word overseer. As a Black woman and judge, I really hate the word overseer. Can we use her official title?
The director of medical, Katie, saying that.
Yes.
I'm sorry, Your Honor. I'll wait.
I just hear the master's whip cracking when you say overseer. But yeah,
Okay,
what's
Your
her
Honor,
title?
you
Is
have
she
4 minutes.
is she the chief doctor or something like that? Or
Yes, the director of medical.
okay.
She there's a message saying that Mr. Benz has not shown up to his appointment.
Yes, that's approved. Any new evidence that you will be adding, and you can just list them. You don't have to explain them, not in
Yes, Your
detail.
Honor. Yes, Your Honor. I do have a screenshot of this is with my motion. This is a screenshot that I am putting into evidence where it shows that a subpoena that was sent to me at 2:22 p.m. was then edited over and over again at 2:31, actually by yourself, 4 times. So I did want to put that into evidence because I do know that the defendant did serve me with that subpoena, but then that subpoena was then edited by you and her multiple times after it was approved. So I am putting that into evidence because I do want to also file a third motion to dismiss this case.
Okay,
Um,
so let's stop right there. There will be no your. I'm preempting your motion to dismiss and denying it. The reason why is because I had to put my signature on the document, and I made her open it up so I could put my signature on the document. Again, if you have a question about the way about my practices or how I do something, that's something that we can discuss in chambers if you have a question for me. However, that has no relevance to this case or how this case is being adjudicated. Now, do you have any?
Your Honor,
Is it? Hope
your
I could watch it.
Your Honor, I do apologize, but you did approve that subpoena at 2:22, meaning
it
that your signature should have been on that subpoena at 2:22 and not edited at 2:25 and 2:28, and then again at 2:31.
You
So I
are
did want to put that into evidence.
you're dangerously close to being held in contempt. As the justice, I
But
do
Your
not
Honor,
need to explain
why
myself. The
would he
reason,
be held
the
in contempt though?
because I said what I said, and I already issued a ruling on that. I already told him that that is not relevant to this case. Number two, I was gracious when I explained to him why there was. I went back into the document to fix the signature. It was a technical issue that is also recorded in
Your
the
Honor, you
transparency of.
did.
Stop interrupt, please.
Landon. Let her speak.
I also explained that, which I do not have to do. Now, subpoenas and when they were signed is not relevant to what we're doing here in the mock trial. We'll continue this in the ease. Everybody, we will continue in the ease. You can disconnect from the server.
They're gonna make this up. They do. I ain't gonna
Why
hold you,
We can
y'all.
Alex?
discuss. We can dis. So, Landon, this is a mock trial. So let's just get this straight right now, and let's address this. This is a mock trial. That's number one. Number two, I am your boss. I am the Chief Justice. If you have an issue with anything that you think is out of line, that is something you request an appointment to see the justice for. That is not something that you try to call your boss out in court in front of everybody holding up the procedure. I specifically asked you for the list of items of evidence pertaining to this case. When a subpoena sign is a procedural or process matter, it has nothing to do with whether the client is right in his claim of abuse by the police or not. If you are not receiving information in a timely fashion, that is a conversation that you would have with me, not the AG, not the DAG, with me. And I'm saying this to you now in front of everyone because this is a learning exercise, and we want to make sure that we are on target and we're on target for the reason why we are all here. We're not here to nitpick at corrections that are being made to help people learn how to do things. We're not here to nitpick at those things, nor do they have any relevance in court. Do I make myself clear?
Yes.
I want this to be
May
the
I say
last.
something?
Oh,
Yeah, yeah.
uh, I
I may
want.
say
I
something
would.
too, Justice.
I would like this to be the last time we have this discussion. I would like for us to always be focused on the case that we are on, and if there's any procedural items or issues that will arise, ask me, okay, and ask me about the proper way to present it. That's why I'm here.
So, so I think him pointing out that those documents were edited several times is great for the teaching moment because it points out things that students or attorneys or whoever should look for when presenting a case or being directly involved in a case. So I do actually think that those are credible points towards this teaching moment, actually.
Of course, they're credible.
And
Yes, I agree with
yeah,
you.
yeah,
Wrong,
yeah.
but
So
there's a
hold up. Let me finish. And then two, Landon knows that, well, DA Landon knows that you're his boss. Everyone here knows that you're his boss. So I don't think that studies saying that you're his boss. We all know that you're his boss. And we also know that I'm your boss, but I'm not going to say I'm your boss. I'm not going to keep saying that. So I think that this mood trial has like caused tension between our team. And I think that we all need to step back, take a deep breath, and try to, kind of pull everything together because it's clear that it's tension. It is tension. And if it's tension over a fake case, then how will it really be when we start taking real cases and get out here? And you know what I'm saying? Like we are one. Like we're all one. All of us work for stateside, so we're all one. So if it's disagreements and turmoil and all this stuff now, like how is it really gonna be when the DOJ takes its first real trial? I don't like it. Like it's so much back and forward. Like it is just too much, and I don't like it because I have relationships with each one of y'all. You know what I'm saying? And to me, it's like we're not on the same page. We are not on the same page.
okay.
We're not on the same page.
I
And I
understand.
don't like that because this is something that we all have worked hard for, some more than others.
Mhm.
And I feel like that
Hold
what
on.
we're trying to do, like
I
we've
got it.
lost sight of what we're really trying to do because of everybody's egos and I don't like it. I don't like it one bit. So with this first batch of students that's coming out of law school, I think that after after this first batch right here, we need to take a break. We need to regroup and we need to get better as being one instead of everybody pushing and pulling against each other and trying to prove points and uh, favoritism. And if it's not really like I don't know.
Favoritism. I understand. So if you allow me to address everything you're saying, which is 100% valid, and I get how that looks come from your side of it. However, this is a teaching space, and there's no better
Hmm.
time. There's no better time than now to set the course of how procedures are to be done. There's a time and a place for everything, which I am being authoritative about. There is a time that you do certain things so that folks are not, as you say, in their feelings about it. Um, Certain types of motions are done at a certain point in time. And because he was doing them in a way that was causing dissension, and publicly, I'm correcting it publicly and making sure that he, as well as everyone else, knows how to do those things. There's no need for pauses and things like that. This is the process of teaching. These are the growing pains of growing a department, right?
Also,
It's none of our first time at the rodeo and all that other stuff. So it's just about saying, okay, well, this is how this is done at this time. And because this is a classroom and educational setting, I have to address that. Otherwise, it doesn't get learned and the same mistake keeps getting done. So letting folks know how to do things. If there's an issue with a process with documentation, bring it to your bring it to your direct report and allow that process to be that process. The problem is we have too many hands in the pot and we're not letting the process be the process. I agree with you. Everybody needs to
Chief,
relax, but let us relax and let me teach. You know what I'm saying? Let's do what we got to do. Go ahead, Landon. What you were gonna say?
Chief, yes, Chief Justice, although I do respect all of what you had just said, um, I did want to address the fact that, sorry, can y'all hear me?
Mm-hmm.
Yeah, so yeah, I do want to address the fact that I did say over and over and over again that I wanted the officer in this case name to be redacted from court filings, and that was not respected. And then right after that, that's when I was being told that there was a NDA that was already signed, and
Mm-hmm.
those NDAs were not produced within the time that was set out for the defense. So I'm kind of like a little bit uh worried that this is something that we're teaching students to basically
Mm-hmm.
falsify NDAs while we're in a court setting, and I don't feel, because you were asked to produce those NDAs within 30 minutes, and then it came like several hours later after you did say that those NDAs were already signed. So that's what prompted me to
Now,
have.
when you say you're speaking of Balthazar.
Yes, because she did. Yes, because she did say that she had those NDAs signed, and I actually do have a clip of her saying that the NDAs were signed and
Mm-hmm.
they were not produced. So that's what then prompted me to not feel comfortable.
Mm-hmm.
I was still talking, but I still was talking. I'm sorry,
JB,
but
please
If that
let him
doesn't,
finish. JB, let him
okay.
finish, please.
But but even after that, that's what prompted me to not even feel comfortable with even doing this mock trial, because then the officer that is actually an informant, an actual informant for PD name has gotten out there. So then this just tarnished the entire case. And this is why I wanted this case to be dismissed, and I wanted this to be done with law students and not actual people that have actual jobs, because then this just tarnished the officer to where he couldn't even do his job anymore. He's actually changed his name and his appearance in city. So this is why I wanted this mock trial to be with students and not with actual people. And this is why I filed several motions to have this case dismissed. But again and again and again, those motions are not being either one looked at, or those motions are not being approved. And I'm
Mm-hmm.
just trying to figure out why. After
Right.
everything happened yesterday, today in court, now we have the law students. So after everything happened yesterday, we can't even get any of that stuff back. Like the damage is already done. So I'm just trying to figure out,
Mm-hmm.
again, what are we doing at this point with this mock trial, and why hasn't it been dismissed after AG said that this case has been dismissed and actually closed? But then coming into the city today, and we're actually doing the case, and now everyone wants to get everything straightened out, and everyone wants to get everything together when the damage has already been done yesterday.
Okay.
Nor
So
was I given an apology for any of the court mockery that I experienced yesterday.
interesting. Okay, so let me first say that I hear your frustration. We don't want you to be frustrated at all, at all. And I'm happy to answer your questions. Why did you drop down? Come back up, please. because I think this is important to address it. From my point of view, and I'll be 100% honest with you, I think there's been a lot of miscommunication, and I would like to nip that in the bud from this point going forward. But I want to make sure that you hear me when I say I hear your frustration, and I would like to answer all of your questions. In regards to the dismissal of the case and the motions that you wrote to dismiss, the motions that you wrote to dismiss were about points of the case, one being a conflict of interest and the other, I believe it was a conflict of interest, and the other was for lack of evidence. That was the reason why the dismissals that the motions that I dismissed, that's why I dismissed it. Any other motions that you might have written for dismissal, I did not receive or do not remember receiving. So I want to be clear about that. And it could have been something that is a fault of no one, because as you know, we are growing a department. Things get lost in the sauce, probably no one's fault, but please allow grace for that. I want to also
Justice, you also said, and it's recorded on your YouTube, that when I did say that I did have a motion for dismissal, you said that you weren't looking at any motion. So did you not receive it, or were you not looking at the motion?
To my recollection, and I'd have to go back and look, I believe I was referencing the points of any additional motions on this case, not for motions that had already been written. Okay? So let me also make clear that this case was and always has been a mock trial case. Now, it was always for the law students. When this case came to me in the very beginning, and our AG, who is in charge of all this, I discussed this with her from the beginning. We all knew that instead of pulling a case from the headlines, we were just going to use something that was already in play in the city that had come across our desk, and that was this case. So from the beginning, I've always treated this as an educational piece. No one was to be banging on bacon or taking anything super seriously, because when this case first came in, I watched the video and said, this does not go any further because it was an act of God, right? I relayed this to everyone or in the high command and said, we're going to use this as the mock trial. Instead of pulling something out of the headlines, we'll use this because it's happening in our world and it's relevant. So this has always been a mock trial. So when the AG decided to dismiss it, we said we're going to make sure that everyone is 100% sure and in their understanding that this is a mock trial. And that's why we're still proceeding forward with it, with the extra clear understanding, as it was always understood from the beginning, that's a mock trial. It's something that would have never been a real case. So honestly, this is not a real case. This is an exercise to teach you guys the process. Somehow, somewhere, everybody started taking everything seriously. So imagine my confusion when everybody's all in their feelings, people's getting insulted, and all manner of shenanigans is happening. So I'm just trying to get you guys.
This case is supposed to be a mock trial, but then we did uncover that there is an officer that's in this trial that was an informant, and now his cover is blown. So right after the damage was done yesterday, now we're coming back today, and is supposed to be a mock trial. Attorney General, that is actually the actual overseer of the DOJ, said
Please
that
stop
this
using the word. I'm sorry, but I'm sorry. That hurts my soul. I really need you to take the word overseer out of your vocabulary when dealing with the Department of Justice. Please. She's not an overseer. She is the Attorney General. Thank you. Just, But I hear you. And all of that happened. All of that happened in real time.
Right.
All of
So the person that is actually over the DOJ, the reason why we're all here, said that this case was dismissed and that it's actually closed and that we would do a new case with the law students. And now we come around today and we're having a part two of what we just experienced yesterday, even though she said that this case was dismissed and is closed.
that is
So
correct
I'm
because
a
it's
little
actually
confused.
okay. So let me make it clear so you're not confused. Um, Cases, the AG and I spoke. We went over everything, and she also agreed that what happens in the court, as far as cases, as far as moot court, and as far as real cases, is under my jurisdiction. When she was reminded as to how things happened, why things happened, she was like, okay, well, let's be 100% clear because apparently there's some misunderstanding. And so that's why I issued 2 memos out today to clear up the misunderstanding and to get everybody back on track. That's my job. That's what I do. That's what I was brought here to do. So the case, I'm here to unconfuse the matter. This was always a mock trial. What happened with that, with the folks coming in um, with JB, the young man knew that the case was going to be used for educational purposes, to my understanding. He always knew that. Him and his folks were compensated. Now, I don't know, and it happened in real time in front of all of us, that that man's name was in that tape, which you did as you were supposed to. Make sure that it was stopped at that moment. The names were redacted. I said, I'll review it in chambers. And if this happened in real life, that's exactly how it would have happened. Does that make sense? So we have to learn how to roll with the punches. Not only that, but the the deputy attorney general then looked into the matter and she's dealing with it. All right. But that doesn't stop the learning and the education that we're doing, or how we have this set up and all the time that went into setting it up. And I understand that you are peeved about what happened on that video, but that was not done intentionally to hurt anyone's feelings. It was a mistake, and we don't need to bang on bacon about it. Let's admit the mistake, correct the wrong, and move on. And that's what I'm trying to get us to do, while also trying to let you understand that there's times and places for things and where certain things apply and where they don't. And I'm doing it so that everybody else understands that as well.
Your Honor,
Yes.
to clear some stuff up, because so whenever you do a case filing, of course, someone files a case, which is what I did. Here's the initial case. Here is the initial subpoena, which of course is the document, which the only thing was edited was the signature because you were having trouble getting the white square from your signature and stuff. So that's what was going on with that. So I was misinformed. I was under the impression we were going by California. So I was under the impression that we did not have to have a judge's signature for a subpoena. You guys later corrected me and said we do. So of course, this subpoena was deemed invalid at the time of the evidentiary hearing. So we're on track. So then Landon filed his motion to dismiss. I responded before the initial hearing. He responded to my response before the initial hearing. You denied it at the hearing. And of course, this is the corrected subpoena where you did like this. And I'm like, go ahead and put your signature on it because I'm going to see if the printers are going to be able to show the document in city. So I just wanted to clear that up, and keep in mind also that there are several motions that can be filed with the city, and it's in the SOPs. So if the officer's identity is private, if there's any private information that requires a closed court, it is the responsibility of the party to submit a motion for closed court. And of course, here's record of all of the motions as well as all of the case updates. No motion for closed court was filed, so no mistake was made. I think that the motion for closed court just never got filed. And of course, that's what led to what it led to. So I don't think it was a conspiracy. I think the
Right.
SOPs
Well,
just didn't get read.
nobody ever said it was a conspiracy, but to my knowledge, whenever there is an undercover agent or a undercover whatever being used as a witness or a point of interest, that court should automatically be closed because we don't want that identity of that person, that officer getting out.
It's the
So
So,
I don't.
responsibility of the DA to file a motion for closed court.
and that is correct. So going forward, we know that as we're reviewing our cases and setting up our cases where we have PD involved, that the district attorney definitely needs to understand who's being called in. If they are undercover, making sure that motion is there so that everybody is
Okay,
aware
but
that
all
the
right, all
Hold
right,
on,
all right,
Landon.
but all right.
Hold
No,
on. Let
because
her
I
finish
literally said
talking.
it in a voice
So
chat
listen,
way
no,
way
no,
before
no, no,
all of
no,
this.
no, no, no,
So
no.
A
At
voice
the
chat's
end of
not
the
a
day,
motion.
you have to be respectful. If she is speaking, you have to let her speak, and then when she's done speaking, then you can state your piece. We're not gonna be disrespectful, and we're not gonna be rude. So let her finish talking, and then you can stay and say what you need to say. That's what I just said. That's what I just spoke about. We're not gonna do that.
so as I was saying, thank you, Dad. Um, the way that it works, both in the real world and here, is that if there is a case that has a police officer whose identity, or any important person whose identity needs to be redacted for any reason, that has to be put in writing so that the entire court is made aware of it. Now, the entire court is, oh, we all have NDAs that we have all signed. Y'all all went through that exercise, right? So that information is confidential. Any other special requests have to come to the judge's desk. I have to sign off on it. If I have not seen it in a timely fashion, you know who the Diamond Love or Mecca are, the clerks of the court, and they can assist you with getting a audience with me so that we can make sure that anyone that needs protecting is protected. This is the process, so we don't need to go backwards and bang on bake and point fingers. We know what happened. Let's admit that it happened and move on to the next step and do better next time. So now we know the process. That is the role of the DA. Okay? Are there any questions about that? Anyone, any students want to, do any of you have a question about that? You can raise your hands if you have something to say or if you would like to. All right. So are we able to get back to the part two of the evidentiary hearing, or are there any more points of contention that need to be discussed? Which Discord are you unable to see? You unable to see the document. Okay. Thank you, Mecca. I agree. Landon, is there any more evidence that you would like to present in relation to this trial and the plaintiff in regards to him proving his police brutality case in defense of the police? Is there anything else to add on that point? Hello?
Yes, I do. Hello,
Yes. Okay. Now I can hear
can you hear
you.
me?
Yes. Is there anything else to add? Do you have another piece of evidence to present?
Yes, I do have. Yes, I did subpoena for. Yes, I do. I did subpoena medical Island Medical for Mr. Ben's appointment or like report appointment or whatever, like medical report, where
Mhm.
it states that he was put into well, let me. Yes, this report does read that he was in the back of a trunk and boxes that fell on top of him, they didn't see any fractures or any acute pain. He actually left with 3 tablets of Vicodin that were 3 milligrams. I do want to put that into evidence as well.
Any objection, Attorney Balthazar?
No.
All right. Next piece of evidence. Do you have any more?
Yes, I do have a picture. Well, I do have a screenshot of them saying that Mr. Bands has not showed up to his appointment for a week and a half. And he was also late 3 times. He did not make his appointment 3 times. My bad.
Any objection to this evidence being admitted for court for trial?
Yes, I object.
On grounds?
Non-probable and biased, missing appointments and schedule mishaps do not hold any bearing towards any of the claims that he's making.
Your Honor,
hold on.
Sorry.
Not unless I ask for rebuttal. I already have my decision on this. Denied. I'm going to allow it. Next.
Your Honor, I also have a audio from a doctor at Medical Island or Love Island Medical that said that Mr. Chase Bands has not did not fill out a ticket when they had asked him and gave him the proper steps to fill out a ticket.
Any objection to this evidence being submitted for trial?
When it comes to audio recordings, California is a 2-party state, so if he provides the consent for the doctor, whoever was recorded, no objections.
All right. The court's going to overrule that in that while we love the dream world for what it is, Island of Love is its own island, and so we will admit that. I think we definitely had determined that the laws of Island of Love, while we love the dream world, it is only a reference for certain things. So in this case, we'll have a reference. But what I will do is I will sidebar with the AG to make sure that we are following that in regards to that code. So make sure you swing back around on me. But for now, the voice evidence is admitted. Anything else?
Yes, I also object to the.
Go ahead, JB. You object to what?
I also object to the admittance of whatever screenshots are associated with you having technical difficulties applying your signature to a subpoena. It is being painted in a way that does.
Yeah, that has no bearing on this. That has no bearing on this case. So that's not even a part of this conversation. Please, let's move on from that and never mention it again. We're moving forward. Landon, any other pieces of evidence for this trial in relation to this case?
Yes, Your Honor. I do have a message between the chief of Love Island Medical and myself, where she details the calculation on how much time it takes for a individual to starve, as said in the subpoena that Mr. Bands did state that he was about to starve and die. I do have a text message from the chief that shows the calculation.
Gotcha. Any objection to this? Now, I understand she's also coming in as a witness to provide testimony. Is this correct, or has this been changed?
Yes, I do have, I did ask that 2 individuals from Love Island Medical show up. That is the director, the chief.
Okay. And they do understand that this is moot court, correct?
Yes, fully aware.
Okay, thank you. All right. Any objection to the testimony from the chief of medicine over at Island of Love Department of Medical Services, attending and providing documentation and testifying in the trial. Any objection?
No objections.
All right, let's move on to the next point. Landon, is there any other new pieces of evidence that you would like the court to include in the trial?
Yes, Your Honor.
Okay, we'll listen.
Can I proceed? Yes. I do have Mr. Chase Band's. I do have like it's like a third paper on his medical report that says that they suggested a stretching uh, section or like a stretching what is it like exercise or whatever for him to not my bad. So this is basically like them saying that he can just do like stretches or whatever
Phys-
since they don't see any bone fractures.
Physical
I do have
therapy,
that
correct?
report.
Physical therapy?
Yes, physical therapy. Yes.
Okay. Any objection to records from the plaintiff's physical therapy records being admitted into evidence?
No, Your Honor.
Okay. So, great. Landon, if you can, you see how I just summarized it really short like that? Try to do it like that, and that will move us along
Okay.
faster. Because you don't wait for the trial to explain like what it is, because then it has that moment to it. It's like a reveal. So here we're just listing out like a general title for it, and then moving on to the next one. Okay. So, what do you have any more? What's your next one?
Yes, I do. This is from the chief EMS, who just said 5 minutes ago that Mr. Vance did not show up for his physical therapy appointment that was
Okay, so you have written testimony
testified.
from the chief of the fire department regarding Mr. Bands. Is there any objection to written testimony from the chief of the fire department?
Not fire department, the chief of Island Medical.
I'm sorry. Oh, I said fire department. My bad. Thank you for the correction, DA. Is there any objection to written testimony from the Island Medical chief of medicine?
Yes, Your Honor. Written testimony can't be scrutinized. I would demand either a deposition or the witness would have to just be in court.
Okay, your objection is overruled because she will be in court, and also it would have been overruled even if she was not, because she is a chief of the city, and her words tantamount to being, I wouldn't say law, but being taken as truth. They hold that position for a reason. Next item of evidence.
Yes, yes, Chief Justice. I do have a picture of a X-ray from uh Chase Vans that came from Island Medical. Um, I do also have the chief uh of Island Medical coming to testify to basically show the court with Cindy's X-ray images.
I understand. Any objection to X-rays being
No.
included? All right. Anything else, DA Landon?
Yes, Your Honor.
Okay.
Can I proceed? Yes,
Yes.
I do also have a report from the chief of Island Medical saying what is this? Sorry. Detailing Mr. Chase Band's prescription plan. He has 0 refills on his 3 Vicodin tablets. I
Okay.
do also have
TMI,
that.
TMI, TMI. Just remember, try to
Sorry.
summarize it in that sentence so that you get that moment during court, right? Any
Okay.
objection to the medical records of Mr. Bansby admitted into court?
Your Honor, to graciously save the court time, plaintiff concedes to all entries of medical record as it pertains to this case.
All right. Excellent. District Attorney Landon, do you have any other pieces of evidence not relating to medical? Because they've already conceded to everything medical being admitted. Is there anything else that needs to be entered into the record for this trial?
Yes, Your Honor.
And it's not medical.
It's not medical.
Okay.
I also have new birdie posts from Mr. Chase Bands. I do have reason to believe that this is his account because it does have the same username as his account in the emails.
Does it happen in the
Going back,
same? Is it the same time frame as the original birdie post that you have previously submitted? Does it happen on the
this
same
has
day?
this has come out after the evidentiary trial yesterday.
It's not admissible because it needs to be pertaining and into the same time frame as the actual incident occurred. So it would not apply in this instance. Okay, what
Okay,
else
can
do
I
you
move on
have?
to my next piece of evidence?
Yes, please.
Yes, Your Honor. I am receiving Mr. Chase Van's business license that he registered after. My apologies. Yes, Your Honor. I do have Mr. Chase Van's business registration license with a time, date, and signature on it. Yeah.
Okay. All right. Any objection to the business license being entered into evidence for trial?
Yes, Your Honor, it's non-probative. It is a well-known fact that the licensing administration in the city is brand new, and it was instated around the inception of this trial. So that holds no bearing as not only Chase Bands' legitimate business was operating, but also a myriad of restaurants, strip clubs, dispensaries, and other services along with Chase Bank. So it's non-probative.
Understood. District Attorney, would you like 30 seconds for rebuttal?
Yes, I do.
Okay. 30 seconds starts now.
Okay, Mr. Chase Vance had registered his business after I sent the subpoena response to his attorney. So I do have reason to believe that she did advise her client to go ahead and register his illegal gun business so that they can be ready for court.
Okay.
And under
District,
oath, I attest to that.
hold on. District Attorney, is this piece of evidence pertinent to proving your case?
Yes, Your Honor.
All right, I will allow it. And the objection of the plaintiff is noted. I suggest you find evidence contrary to what he's presenting. All right. Next.
That was all, Your Honor.
All right. So now, is Diamond still with me? Diamond? I think Diamond. I'm going to bring Diamond up. As you guys know, when I bring Diamond up, that is because we've reached the end of a process and we need to schedule something. So students, just so that you know, if I call for Diamond or Mecca, Mecca, you can come up as well if you like. These two are the heart and soul of the department. They keep records on everything. If you want something signed, if you want a date scheduled, you must go through Diamond and Mecca so that they can route it to the appropriate person, right? And although we've had all these little hiccups and things like that, we are now at the point in the process where everybody is positioned to where they're supposed to be. So the growing pains that we've suffered over the past 2 weeks are now done with. Mistakes will still be made. So allow each other grace, allow each other grace. We're here to have fun. We're here to have fun. Okay. But in order for us to keep that fun, allow Diamond and Mecca to keep our crowns adjusted and make sure everything that you do, they are witness to. First rule in law, always have a witness to everything you do. All right. Diamond is my witness. So, Diamond, can you tell me Sunday, are we good to go to trial? What time is on the calendar for Sunday for the final
Yes, if
trial?
I'm not mistaken. Give me a second. We scheduled moot court for 7 o'clock for 19.
Okay. So, everybody, if you are okay with 7 o'clock on Sunday, just throw up something in the air in the chat for me so that Diamond can make sure that everybody will be there. And I will be assigning you guys roles in this. Okay. Some of you guys will be jury. Somebody might serve. We might have our parole officers on board. I'm known to hold people in contempt of court. We might have to act like we're taking somebody out of the court, JP. but you know what I'm saying? But for the most part, you guys will be serving as jury or advisors to the jury. Remember, we do have a real world jury that has been with me for the past 2 years or more. They are also well aware of this mock trial, and they've been aware of that from the beginning. So they'll be on board as well. So can everybody make it? Okay, Jade, you're going to be fine. All right, so look, 7 o'clock, Sunday. Now, I'm going to set the rules for engagement from now for Sunday. Each side will get 3 questions, and I'm going to write this out and make sure y'all have it. But court cases, and especially hearings, should never be more than 60 minutes, okay? I've been allowing it to go on this long because I know we're in a learning process and we're having, this is moot court. But even now for moot court, this will no longer go on for more than an hour. I need you guys to be succinct in your questions, succinct in your answers. Nothing should be more than 30 seconds at any given time. During trial, you get to ask, I think it's 7 questions and 3 questions on rebuttal. I'll make sure that process is provided to you guys and given to Diamond and Mecca so that she can distribute it to each of you. And then if all of you want to, make sure you review it, quiz each other on it, because hopefully it'll be on your final examination, this process. All right. Remember, we have folks that are watching, and we don't want to bore them to tears. I don't want to be bored to tears. The client don't want to be bored to tears, and people come to us. At the end of the day, this is still RP. We're still supposed to be having fun and make content. So don't take yourselves too seriously. Have fun with this. We're not banging on bacon. All right?
That's the countryest thing I've ever heard.
Listen. All right. Dag, do you have anything before I dismiss the court?
No, I just want to reiterate on what you said about everyone having fun, and we're just going to try to keep it as professional as possible. And other than that, let's get to it.
Mm-hmm. All right, guys. If you need us, we will be in the E's. Make sure you hit up Diamond or Mecca for anything that you guys need. And with that being said, I will see all of you on Sunday. All right. Oh, and if there's something you specifically want to do for Sunday, let us know.
Your Honor, I did put out a subpoena that does have a deadline of some.
Did you give it to Diamond to get it to me? Because otherwise I won't see it.
It's the same one you signed.
Oh, it's the same one. Do I have to sign it again?
No, I'm saying the subpoenas have a 48-hour grace period, and I'm saying that court is right at the deadline of that, is before the deadline of the subpoena.
Right. Let's not bang on bacon with it. I mean, this is, well, if we get it, we get it. If we don't, then we roly-poly with it. We're not going to, no one's life is hanging in the balance for this. This is for educational purposes. All right. So we just use what we got. But when it becomes, as you know, if it's a real case, then obviously there'll be real consequences for that. So, trick question. Jury duty, yeah. Kyra, you can do their second chair because JB doesn't have a second chair as of yet. So I might assign one of you to shadow with her or be her second chair. There's the jury, there's the bailiff of the court. I know the parole officers will be in effect, so they'll be playing themselves. And I think the remainder is the jury. All right, so make sure you guys familiarize yourselves with the suit. If you don't have access and you can't see the suit, make sure you let Diamond or Mecca know that you need to be able to read the suit because you're going to be expected to write your suits just as professionally as the one you're about to see.
Oh, can
Um,
I mention something, Chief Justice? I'm sorry.
yes, ma'am.
Also, all motions have templates in the ease, and we expect you guys to use those templates for all motions that you need to file. So for future references, if it's a motion there that you need and you don't see, just give it one of us, and we will create a template so that everyone is using the same templates.
Mm-hmm. Right.
Oh, and Your Honor, honestly, just for case efficacy, I actually do need that subpoena just for this situation to be
Okay.
enforced.
Okay. Now, all right. So we'll talk about the what I ran into earlier today offline. But let me go ahead and dismiss everybody. You guys, thank you so much. I appreciate y'all for spending this evening with us. I know some of you have a wedding to get to. Um, happiness to the bride and groom, of course, and to the rest of y'all. Please have a wonderful, wonderful Friday night. Hopefully, y'all
Hey.
just got paid like Johnny Kemp. Good night, y'all. To my folks on TTCCTV, Passe, Stona Lisa. Oh my God, all of y'all are in here. Hey, what's up? Oh my God. Hey, y'all. Hey. So Sunday we are back with the. It is a mock trial, as you guys know, a moot court, but it is still
Why look like you got
court. Okay, so I hope that y'all are there because I need y'all to help me teach my my youngins, my YN attorneys that are coming in to do this next iteration of court. I know you guys are excited. I'm excited too, and I want to thank you guys for rocking with us all these years with this. All right, so I will see you guys Sunday at 7 p.m. All right. Make sure y'all spread the word. Let everybody know what we're doing. We need y'all support. Love y'all. Peace.